one more time. Heather White from Snowcrest and Martineau. Heather.
Thank you for having me here today. We're going to talk just a little bit about the law enforcement legislative updates that took place. The legislature was pretty busy dealing with law enforcement issues this year, particularly with the body camera issues. So I think most of the time is going to be spent doing that. For case law updates, I will continue to send those out to those registered with me to receive updates, and if you have any questions about anything that you see or anything that we send out, just let me know. If you are not signed up to receive those emails, just let Jason know or let me know and I can get you put on that list. We try to send out those emails of case law updates every couple, 2 to 3 months, and try not to burden people with everything, just sort of hit the highlights. So with that, let's start with the legislature this year. Doug, it's not changing my slide here. What am I? There we go. So tap it instead of the arrow. Okay. Oh, it's working. Okay, great. So the first thing that the legislature did, one of the amendments that they made was to the statute that addresses assaulting healthcare workers. And we were really glad to see that they increased the penalty for assault against healthcare providers and emergency medical workers to a third-degree felony under certain circumstances. And those circumstances are as follows. First is when the assault causes a substantial bodily injury and the person acts knowingly. So those elements have to be met. So when law enforcement officers are out or emergency medical workers are out, and something like that happens, an individual can be charged with a third-degree felony now, as opposed to, I think it was a misdemeanor before. So it's good for law enforcement to know that. That became effective earlier this May. Most of the statutes became effective in May. There are a couple that are going to be coming up at the end of October, and I'll show on each of those statutes which ones those are. The next thing that the legislature tackled really was the body camera issues, and there are several statutes that are listed that deal with those. It's been a hot topic, not just here in Utah, but around the country, and I think it's a really good thing to have legislation that governs, but what we want to make sure is we have good legislation. And I'm glad to see that they didn't rush through too much and try to impose too many restrictions that they couldn't agree upon this year. They reached a stalemate last year and this year on how to store those things, how much had to be provided, what was protected, what was privileged, but they did make some headway into things. And one of the things that they did is they established that when we do have body-worn cameras, that a policy, that the agency using the cameras have a policy and it needs to meet the minimum guideline standard. And that is what is set forth here in the statute. So we'll go through those so that everyone is aware of what those are. The minimum guidelines first start out with ensuring that an officer verifies before the officership that his or her equipment is properly functioning. Now that doesn't mean that there can't be malfunctions, when things happen or the officer might forget to turn it on at the appropriate time, but the officer needs to verify before each shift and document that somewhere that the equipment is properly functioning. And then if it's not, then that the officer report malfunctioning equipment immediately to the officer's supervisor. It would be make things difficult if an officer knows that the officer's camera is not properly functioning and doesn't report it in time. We've had instances where that's happened with dash cameras, and it's always a challenge to explain why that happens, and it's for the officer's own benefit as well, to protect the officer and the agency as well as the individuals out there. So make sure that your policies include all of this information. The next requirement is that the officer wear the camera where the person who's being recorded can see that there is a camera and that they're being recorded. And really, we'll get into it later. It's a matter of privacy that people behave differently, except for if you're watching reality TV, of course, so when they know they're being recorded. And so it gives them an opportunity to be on their best behavior, everyone, to ensure that they don't say certain things that they don't want to risk being made public. And so part of doing that is to ensure that they know they're being recorded, and that's why there was this implementation of the visibility of the camera. The next requirement is that the officer activate the camera. That's going to be something that I think officers are going to struggle with a little bit as they get used to wearing these body cameras. And so there may be some delays. And so I think they built in this as reasonably possible. But again, it's for the officer's benefit to have this. So the officer might think on a traffic stop that they may not need to activate things until they get up to the person's door, but it's really helpful to have the information about what their driving pattern was, if that's something that would be shown on the body activated camera, or if they don't have a dash camera. So the model policy requires that it be activated as soon as the encounter begins. And it's really never too early to start that recording for the officer's benefit as well as that of the public. And if the officer does realize that he or she has forgotten to do that, to turn that on as soon as possible. And the next minimum guideline is that they record the encounter completely through, that there not be any stops, pauses. There are situations as we go further through the statute that is appropriate, and actions that need to be taken when that is indeed done. But for the most part, they want a continuous recording until the conclusion. So we have recording from the beginning till the conclusion, and we've talked a little bit about what beginning of it means. The conclusion, I would say, really is after the person leaves, if they are cited and released, or if they are arrested and taken to jail until custody is transferred. We've had instances where the officer didn't continue recording while the person was in the car, and then it became a matter of the officer's word versus the arrestee's word about what happened in the car, and on the way into the jail, and what happened in the jail. And so keeping that recording going will help prevent any problems related to that. Now, there are, as I mentioned, situations where the camera may be deactivated. And the statute, the legislature provided, and the statute says that there are instances where an officer needs to talk with a supervisor or another officer. Instances where that may occur might involve strategy, say, for example, on an officer-involved shooting, or a SWAT operation where certain strategies are employed that really need to be kept confidential. That could be the case. There are other instances, I'm sure, that you can think of, but be very discreet about those. Err on the side of recording, and redactions can be made later if that's necessary. Another time when the camera can be activated is when there's a long period where nothing is really occurring. That happens. We have that happen frequently on officer-involved shootings, where someone is not sitting with a witness or not doing any investigation, merely holding the line and nothing is happening. And again, it's that the officer may deactivate, but it may be in the officer's interest to keep that going as well, because you never know when someone might approach the officer at the line and there may be some issues. things that they might say, witnesses might have seen things. So I always recommend leaving it on, even if you think nothing's happening. Maybe something is happening that you're not aware of or might happen, and it's a good idea. The next time that that the statute allows a person to deactivate their camera is really one I think that is the most important, and that's where you have a victim of a crime and there's a conversation going on with that person, either a victim or a witness who wants to share what the person has seen or heard, and their sensitive information, particularly when you're talking about children that are involved or medical information. Again, it's up to the officer's discretion. My recommendation would be to ask the person, to let them know that they are being recorded, and then to ask them, you know, if they have any objection to that, because things, again, can be said that might not seem important while something is happening, but later down the road can become critical. So I think it's helpful to keep it on if possible, but officers are allowed to disengage the recording for that. If the individual requests that the subject deactivate the camera, then the officer really is required to do that. Or if the officer feels that the information outweighs the value of the recording, that is the discretion that is allowed as well. So there are those components to it, and that really coincides with my recommendation that you let the person know that they are being recorded, so then they have the opportunity to object or not. And there's no perception that the officers are trying to hide something because they're switching it off. The other thing that officers are required to do as they start the recording is to record at the beginning their name, the beginning of their shift, each shift, their name, identification number, current time and date when they're going off of duty. Now that is sometimes documented on the officer's camera, and if that is the case, then it takes care of that information. But as a matter of practice, it's a good idea just to have the officers do that in case there's something that goes wrong with the technology or not all of the information is included. And it helps just in the context of showing the recordings at the appropriate time without having to go over all that information. It's right there on the recording itself. The minimum guidelines, and I think this is a good idea, also require that the officer document the presence of a body camera in any report that the officer has. So whether it's recorded or not, the officer needs to put in their police report whether they had a body camera and then whether it was recording or not. And that's just a fail-safe to ensure that the officer is protected from claims further down the road that they had a body camera where they might not have and weren't using it, or vice versa. And then another reason, and this just goes back to the importance of report writing, which I always harp on, is that they document the reason for deactivating a camera for the in the report as well. That helps, so that's documented maybe on the camera and also in the written report, and that just provides corroboration for the officer for things that occur down the road, so that people can't then go back later and say the officer made something up. Continuing on, the legislature really dealt with, addressed and discussed and debated privacy and notice issues. And again, this goes to the when it's you know, when you might deactivate or not deactivate a camera. When an officer enters a private residence, they are required to let the people know that they have that they're wearing a camera, and also wear it in the place where it's seen. So earlier, the requirement is, the minimum standards require that it be worn in a visible manner, but not announcing it. My recommendation is announcing it, although there may be some instances where, for certain reasons, it shouldn't be announced. But here, if the officer is entering home, it is required that the officer let people within the home know that the officer has a body camera and that it is active. And then the legislature wants to ensure that the public has access to all of the policies about use of body cameras. So it requires that those be made available. How that is done is left up to the agency, but it does recommend placing them on the website, the agency's website, when possible, so they're always available to the public. And then it also goes on to detail what prohibited uses are of body-worn cameras by law enforcement officers, and we'll talk a little bit about those. Those legislative changes were implemented and became effective on May 10th. So if you don't have policies that are in line with these minimum guidelines right now, it's very important to get on that and ensure that you take a look at these statutes. Don't just rely on my summary, because there may be some details in there that need to be provided in the policy. And that's why I provided the actual code sections, so that you can look at those and ensure that those get taken care of and included in the agency's policy. So let's talk a little bit about the prohibited uses of body-worn cameras. Officers are not allowed to use them for personal use, anything that really doesn't have any bearing upon the officer's job as a enforcement officer. Another is that officers are not allowed to make their own copies of any recording or to keep any recording on their own. They need to be turned in where appropriate. They should be booked into evidence, and ensuring that there can't be any modifications or allegations that a modification occurred. And then also, officers are not allowed to duplicate their body camera or provide a recording to anyone else. They're not authorized to alter or delete a recording either. And this is really for everyone's protection. So I think it's good to have in a policy a requirement that the officer download the recordings from their body camera at the end of a shift, and have something in place that turns that over to someone else in IT, whatever it may be, whatever is the best way to do that, where the officer no longer has any type of control over that. And a lot of recording systems, most, I think, if not all, don't make the officer able to delete or alter anything on the recording. So if that is not the case, then take a look at policies and how to ensure that that does not happen. The one thing I mentioned that the legislature really wrestled with is it's coming up with their own standard of retention, and so they just sort of defaulted now for as provided by federal, state, and local laws. So these changes in these statutes became effective May 10th of this year as well. Those are the changes that were made to body cameras. There will be more, I'm sure, in the coming legislative session that will deal with protection of and distribution of the cameras. And I know that's been a hot topic in the Salt Lake Valley over the past year, and I'm sure locally and nationally will continue to be. So look for that to be something that the legislature will address, and if you have an interest in that, ensure to speak with the lobbyists who deal with those issues, so that our agencies are heard on what is important to and feasible for them. Moving to the next legislative changes there were changes in child pornography reporting requirements. These won't necessarily deal with law enforcement officers, but may apply to crime scene technicians or people who are working in that. And it requires any computer technician who finds child pornography on any computer to report it immediately to law enforcement. That will maybe affect how law enforcement receives and addresses investigations of child pornography. So it's good to be aware of those. Failure to report, the willful failure to report it, is a class misdemeanor now. And so if a computer technician does not comply with this code section requiring reporting, then a law enforcement officer may cite that person for criminal behavior as a Class B misdemeanor. That became effective on May 10th as well of this year. Moving to the next section, the legislature made some changes to cohabitant abuse. And there are several changes that the legislature implemented. The first prevents the release of a person arrested for a domestic offense before that person is appears before a magistrate judge or before signing the jail release agreement. So there are certain forms that need to be implemented. And again, this became effective in May. So if you don't have those, it's probably a good idea to talk with other agencies who may have those in place and be using those. Second, it requires the officer to tell the magistrate judge before whom the person appears if the victim waived certain release conditions. As you all are aware, there are forms that comply with these sections that require the victim be notified of certain issues related to release, and they are authorized to waive those, but now officers are required to inform the judge before whom, the magistrate judge before whom the arrestee appears, whether or not that person has waived that. And then finally, it requires an arresting officer to provide certain notices to the victim and the person arrested for domestic violence. And those are set forth in the statutes. There are numerous requirements. You want to make sure that the forms that the officers have include all of those notifications so that there isn't a claim later by a victim that they weren't, or an arrestee that they weren't provided with certain information. And this became, as I mentioned, effective in May. The next subject that the legislature addressed was consensual activity of minors. We had the case up in Davis County that dealt with the teacher who was having sexual relations with her students, and I think that prompted some of these changes. What the legislature did was reduce the age differential for sexual abuse of a minor from 7 years to 4, where the person is an adult, a teacher, employee, or a volunteer. So those are people who hold a position of trust over the minor, and I think the legislature was trying to accomplish that so that it would make the crime and the punishment for that more severe. And what it did is, when that person falls within the 4-year limitation and that protected or not protected the area of trust, the person holds at that level of trust, then it becomes a third-degree felony, and they are then subject to be placed on the sex offender registry. The legislature then reclassified some of the crimes and stated that it reduced the offense from a third-degree felony to a Class B misdemeanor where there was a less than a 4-year difference, and where it was a first-time offense and the offender was younger than 21. So there are some changes. People under those circumstances are not subject to the registration on the sex offender registry, and it's important to be aware of those as we're investigating and citing and charging people. Those changes also became effective on May 10th of 2016. This year was there were efforts to change the controlled substance database. There have been, for the last several years, efforts by attorneys and lobbyists to really limit access to the controlled substances database, and there were changes to that went into effect this year. The first requires the medical examiner to provide to DOPL a report when the medical examiner concludes that a death resulted from overdose or poisoning, something involving a controlled substance. So that's a change. And it also now requires DOPL to notify each practitioner, medical provider, who may have a prescription of the poisoning or overdose. And I think they're trying to get information out to doctors who may be overprescribing, or to doctors who are being used by people who are shopping doctors for medication. Information sharing to try to prevent tragedies from occurring and to help raise awareness of those issues. The changes also allow now probation and parole officers to obtain information in the controlled substance database without having to obtain a warrant, but it limits law enforcement officers now in obtaining that information. It used to be that any law enforcement officer who forgot an account would have access to that information, and only DOPL would know what they were doing and could access their accounts. Their agencies could not do that. Now, only officers engaged in certain types of investigations are allowed to obtain information about their controlled substances database, and they are also limited to the information that is provided. The information now that they are able to obtain is the gender of the person involved, the year of their birth, their zip code, and the officer is limited now that the officer has to be in a joint investigation with DOPL or be an officer that the division has referred a suspected criminal violation of controlled substance laws to. So this is one of those that is now becoming effective at the end of October, and it will result in changes to how law enforcement officers are allowed to use and access the controlled substance database. There were also amendments that were made to the Department of Public Safety statutes. The first is that the State Bureau of Investigation now has the authority to investigate crimes of public corruption by an elected official or an appointed official under certain circumstances. And the legislature has outlined those as at the request of a governmental entity, or when the offense that is involved is reported to peace officer standards training. And so what that is geared to do is try to eliminate some of the appearance, or not that there is any bias, but eliminate any argument there's bias by having the State Bureau of Investigation, who doesn't have interest in any of the day in and day out workings of the entities, to conduct these investigations. And it also allows now the Public Safety Commissioner to authorize the off-duty use of emergency vehicles. That is something that can affect officers on their day in and day out workings. Those changes became effective in May as well. There were changes next to the DUI enforcement funding. I thought this was interesting. It's not going to affect how officers do things, but it will affect how fees are paid for DUIs. And what it does is it increases the fees for impounding a vehicle that are to be borne by the driver, and it also includes reckless drivers, by $50 from $350 to $400, and it increases by $50 the fee to be deposited in the DPS restricted account. So I thought that was something that could have an impact on law enforcement because of the funding issues and how those will be used. That became effective in May of this year as well. There were some gang enhancements that the legislature enacted this past session, and it adds retaliation against the victim, witness, or informant as an enhanced penalty if the person who committed the act was engaged with criminal street gangs, and there were 2 or more persons involved. So that is important to be aware of as our officers who are investigating gang activity are investigating and citing people with those crimes, that they know that there's this retaliation statute that can be cited as well, and that became effective in May earlier this year. There were some human trafficking safe harbor amendments that were enacted. It now prohibits a child who has been engaged in child prostitution or sexual trafficking, solicitation, those kinds of things, to be subject to delinquency proceedings. And it amends the Juvenile Court Act to include trafficking of a child for sexual exploitation. So those seem like good changes and timely changes, probably things that our law enforcement officers were using their discretion on anyway, but codifies that. Those became effective in May of this past year as well. There were changes next to the interlock restricted driving amendments. They really relate to employee-employer relationships, and it requires an employee in the service of an employer to meet certain requirements when the employee is an interlock restricted driver. First, it requires the driver to have the employer's permission to drive the employer's vehicle, so that the employer knows that the person is an interlock restricted driver. And then the next is that it prohibits the employee from operating that employment vehicle for any other purpose other than the employment relationship. So they can't use it for any personal use and try to get around the interlock restrictions on personal use vehicle operations. And then it also requires, in order for the interlock driver to meet the requirement that the business entity employing that person be not owned or controlled by the employee. So, if the interlock driver is the owner of a company, they won't be able to use the business vehicle for their, even for employment purposes, to get around the interlock restrictions. And it also requires the employer's auto insurance company be notified that the employee is an interlock restricted driver, and have that person, have the employee be added to the auto insurance of the employer as an operator of that vehicle. That's for the public safety and well-being in terms of having the appropriate insurance in place in the event that something does happen. And then finally, it requires the driver's license division to post the ignition interlock restriction on the driver's license or other electronic, not on the driver's license, excuse me, on the record available to law enforcement. So law enforcement is aware that the person now is interlocked, not just based on maybe what is seen in the car. So those changes became effective in May of this year as well. The next changes that occurred were to put law enforcement on public lands. I won't spend much time on this at all, but it just permits the chief executive officer of a political subdivision or county sheriff to determine with the BLM or the United States Department of Interior if they're complying with certain provisions of federal law, and if they are honoring their agreements as required, and whether or not a federal law enforcement official is exceeding their jurisdiction relating to land. So that became effective in May 10th. If that is something that affects your jurisdictions, I would recommend that you pull those two statutes listed at the top of the slide and take a look at them and ensure that your officers are aware of and understand, and also that the administration is aware of and understands the rights and responsibilities related to those. The next change that the legislature implemented was the law enforcement officer training, and this is something that I had the opportunity to participate in early this spring. It is an amazing program that the Attorney General's office has engaged in. They've purchased some very expensive equipment and are using now interactive training for law enforcement that addresses the practices and how to reduce law enforcement use of force, and to help really help officers understand the legal limitations and foundations of their authority and I think this will help all of our law enforcement agencies. Those who participate in them will have further protections on training claims, both against the officer and against the entity, and will also then help provide the officer with that day in and day out training that when they're encountered with certain circumstances will be more of a muscle memory than something that they have to think about. What it does is it makes available the materials statewide to law enforcement agencies, and it all includes this training center that I talked about, where it's this interactive training on use of force. It's a virtual reality simulator that includes things such as pre-escalation and how to try to de-escalate things ahead of time. In the training that the officers go through, they are engaged in certain situations where they talk with, do they shoot, do they not shoot? how do they deal with, and the different scenarios based on what they decide affects how the person responds. It's really quite ingenious, and I've been practicing this type of law for the last almost 20 years, and it was perspective altering for me. And so I think it is I highly recommend it for all law enforcement officers and agencies. It focuses on where people are possibly resisting and how officers can respond in ways that involve options other than force, and helps the officers see and develop skills, decision-making skills, in using force when that is appropriate. And also just plain decision-making. Do I talk with these people? Do I negotiate with them? What are the potential outcomes of that? So it's very helpful and interactive on those lines. It also can measure if the officer has hooked up the stress that they are feeling during certain threatening situations, and provides them with resources with how to tactically disengage. And of course, the legislature had to throw things because they don't recognize, well, I shouldn't say that they want to make sure that we do what we already know, and that is recognize the sanctity and preservation of life and take actions to preserve those and ensure that those are protected. They also help provide for investigation and critiquing of past uses of force and learning from those in the future about how to respond. And then, as I mentioned before, different legal foundations and authority and reviews of those. They also address investigations of use of force incidents and documentation of use of force. And these are things that really are critical, as we talked about earlier in our officer-involved shooting webinars, about what occurs at the beginning can really set the table for the remainder of the case. So I highly recommend that you call Ken Wallentyne and get involved in that program that he is implementing for the Attorney General's office, and avail yourself of this great resource that we now have. We only have a few more minutes, so we'll just quickly run through the rest of the slides. One of the changes that was made is that it addresses the line of duty death benefits, which none of us like to ever have to deal with, but it's good to know that before employer-paid health coverage for a surviving spouse was relinquished when the surviving spouse remarried, and the legislature changed that so that the surviving spouse is able to benefit from the employer-paid health coverage when the spouse, if and when the spouse does remarry. And then it also specifies procedures for employers that they need to engage in ensuring that such benefits are covered. This became effective in May. The legislature next dealt with changes to the sex offender registry itself, and added as a Class A misdemeanor offenses of enticing a minor and voyeurism, when removal is appropriate, and then how a person is to go about petitioning to reduce the time on the registry, and if they're denied, the time limitation for them doing so. So those are contained in the above cited sections. And then there were several changes made to pawn shops and notifications. I detailed those pretty much, pretty thoroughly in the slides that I think are available on the Trust's website. So I'm not going to go over those because it looks like I think we're out of time, aren't we, Doug? About out of time. That became effective in Are we okay? Okay. There are several slides that deal with this. So all the statutes are listed at the top of the slides, and I recommend that you both read the summary and go through each of the statutes and ensure that the forms that you have relate to or have the information that is required. And then the second to last changes that were implemented were to retirement. These are numerous. They are complicated, and so we just don't have the ability or time to go through all those. So what I've done on the slide is list out all of the statutes where those changes occurred, and those became effective in May. I think the law enforcement lobbyists are pretty up to speed on all the changes and can summarize those pretty concisely, but I wanted you to have those statutes. And then really just ending with the most important is the changes to the bedding amendments. Now you know that if you remove the mattress tag, it's a federal offense. So, no, they did it's a death. It's punishable by death. They actually did make changes to the bedding amendment. That has no interest to you. I just thought it was kind of funny after a long series of law enforcement related changes. So that concludes the legislative updates that related to law enforcement for this past session. And I'm happy to answer any questions if anyone has any. And if you think of something later, again, please just contact me directly, and I'm happy to do so.
All right. Heather, we do have one question. Let's see. Oh, I had it up on your screen there. Can you clarify, I did it again. Can you clarify House Bill 159 on the repeal of the provision to provide health insurance for a spouse that remarries? Does this mean that we are required to continue health insurance for the spouse of a fallen officer when the spouse gets remarried or not?
Yes, that's what the statute provides now.
Okay. Let's see. It looks like that is. I've been prodding them along for questions, but I think you've been so clear on all of this that they've got it. Folks, last chance to ask questions. Once again, remember this material is here as well. You can review those. That's a lot of stuff.
It's a lot of stuff. Just make sure you remember the bedding amendment changes.
Yeah.
Punishable by death, that's right.
I'm excited about that one. That's great. All right. Well, it looks like that's all the questions that we have, and we're just approaching an hour. So we'll go ahead and wrap that up. Thanks once again, Heather, for providing us with this plethora of information. This is stuff that most of us just aren't going to go out and chase down on our own. So we really appreciate that, helping us stay on top of that. We do have some compliments coming in, some thanks from the attendees, so we appreciate that. And folks, if you have some additional questions, feel free to contact Heather or give us a call or an email, and we can work with her as well. And if you have some ideas on topics for future webinars, we'd love to hear those as well. Final words.
Thank you, everyone, for attending. I look forward to continuing to work with you. And as I mentioned before, if you have questions about this or anything related to your government entities, please feel free to call me, email me, contact me in any way. I'm happy to help whatever way I can.
Okay, thanks, Heather. Appreciate it. Thanks, everybody. Please go out and have a safe day.